Reporter's privilege is a right invoked by journalists who want to protect the confidentiality of their sources. There is no federal statute that outlines reporter's privilege. It is derived from the First Amendment's provision for a free press. Most states have some form of a shield law that outlines reporter's privilege. Although there is no federal statute that outlines reporter's privilege, most journalists view it as an obvious right provided through the First Amendment. However, in the court case Branberg v. Hayes, the U.S. Supreme Court refused to set a precedent that acknowledged reporter's privilege for every journalist. They argued that such a privilege infringes upon the legal system by protecting criminals from being tried for their crimes. One of the first notable cases regarding a non-traditional journalist and reporter's privilege was Von Bulow v. Von Bulow, a 1982 case. The New York Second Circuit Court stated that a non-member of the press could invoke reporter's privilege if he was able to prove that he intended to disseminate information for the public, and such intent must have existed at the inception of the news-gathering process. Much later, in 2006, in the court case O'Grady v. Superior Court, a California Court of Appeals ruled that bloggers could be protected by the state shield law if their website resembled traditional periodicals. This was based on their publication habits, the number of articles they published weekly, and the number of monthly visitors they received to their website. One of the most recent cases of a blogger invoking reporter's privilege is that of Tina Renna, a New Jersey blogger who was subpoenaed by the Union County Prosecutor's Office for the names of 16 employees whom Renna had accused of unethical conduct after Hurricane Sandy. The New Jersey Superior Court judge held that Renna obtained material in the course of professional news-gathering activities with the aim of disseminating it over the Internet. Therefore, Renna was allowed to invoke reporter's privilege. Another case involving New Jersey shield law is Too Much Media versus Hale. Shelley Hale was a blogger who attempted to expose corruption in the company Too Much Media, which was an adult entertainment software company. However, she was sued for trade libel and defamation after posting the information on a public forum. The court decided that Hale couldn't prove her intent to disseminate news, and they actually compared her blog post to letters to the editor in the newspaper. She was not allowed to invoke reporter's privilege. So far, it seems the courts have been pretty cautious in cases involving bloggers and reporters' privilege. Well, they have good reason to be, because establishing a precedent for who can and cannot be considered to be a journalist in the eyes of the law will likely have big consequences. The Internet provides anyone with a laptop and a Wi-Fi connection the opportunity to be a citizen journalist. This can certainly be a good thing, but that doesn't mean that everyone who starts a blog is doing so with the intent to provide the public with truthful information. Because of the vast variety of blogs, it doesn't seem practical to establish a precedent stating that all bloggers can be categorized as journalists. Because of the nature of blogging, it is unlikely that the court system will come to a decision that categorizes all bloggers as journalists. However, it's obvious that the issue isn't going away. Blogs will only become more prevalent and widely read as time goes on, and it's likely that more bloggers will demand to be covered by shield laws that protect journalists. The best solution will probably be a Supreme Court decision that acknowledges that journalism can exist in non-traditional forms like blogging, and that bloggers may invoke reporters' privilege if they meet certain qualifications that would put them in that category.
I think that to the extent that states recognize a privilege to keep one's sources confidential, either by judicial decision or by statutory enactment, and if there is a federal privilege that someday gets enacted by the United States Congress, it's going to be very, very difficult to keep bloggers on the outside of that, because they're now an important part of our national culture. They often do engage in what is clearly a journalistic function, and I think it's going to be very difficult as a matter of principle to say that the amateur journalists of the blogosphere are disqualified from this protection and the mainstream journalists are. Of course, we don't know how that will play out, but I think that's one of the pressures that's inevitably out there, and I suspect the bloggers will win. One other point worth making is that the very fact that bloggers may have a perfectly legitimate case that they should be treated just like everybody else may actually have the ironic effect of causing states not to recognize the privilege or to diminish the applicability of the privilege, because it may get to a point where essentially everybody on the internet would have it, and that would undermine the normal rule, which is that you have to give evidence when you're in possession of evidence.
From an ethical standpoint, reporter's privilege is a bit of a gray area. The purpose is supposed to be to provide the public with information pertinent to their lives that they otherwise would not be able to obtain. At the same time, the sources journalists protect with reporter's privilege are often people who are involved in the issues to begin with, people who perhaps should be held accountable for their actions but aren't because they have been offered confidentiality. Ethically, reporter's privilege should be determined on a case-by-case basis for journalists who feel the need to use it. They have to weigh the cost of providing confidentiality to a source against the benefit of providing the public with important information. Does the public have a right to know about what's going on? The answer is nearly always yes. However, perhaps sometimes the more important question is, does this person I'm protecting deserve to own up to his actions? Am I enabling him to get away with corruption or unethical behavior by protecting him? If the answer to that question is yes, then it is on the journalist to make the right call.